let me give you a background. At the outset, this NAB law, which is now 23 years old, because it came into effect 3rd of November 1999, and we are sitting in August 2022. This law has failed to control and curb corruption in Pakistan. And according to the view of the Supreme Court, in a number of judgments, this law has been used for political engineering. Now, with this background, I have always suggested that there should be a constitutional commission which should have a constitutional protection to oversee the process of accountability throughout the country. Maybe it's in the provinces or in the federal government. Now, we come to the specific amendments which were made during the last 2 months, because the present amendment can only be understood if we look at the boilerplate or larger amendment that was made in the previous one. Now, under the last big amendment, which almost changed every section or substituted every section of the NAB law, was given a retrospective effect, meaning thereby that the purpose was to undo various judgments and investigations that were underway. Forgetting that in a number of cases, I would not be focusing on which person got the benefit. I will give you overall picture. That it is a criminal law, and if the judgments have attained finality, then this amendment is useless, because then that would amount to violating or overriding the judgments of the courts which have attained finality, which under our scheme of constitution cannot be done unless there is a constitutional amendment. And in this case, what has happened is that not only they have changed systematically the whole law so that they try to get benefit from this law to undo previous judgments as well as the proceedings which are now. Now, this is the background. Almost 26, 27 sections of the previous NAB ordinance, which was also amended from 99 to 2002, 2021. Now, these new amendments further almost substituted, repealed, and amended the NAB law. And that one object of these amendments was to undo the investigations as well as the judgments which had attained finality. Now we come to the present law, which is your question, specific question. And that is now the main stark amendment which we notice in the Thursday amendment is a new section 31A and a new section 31B has been added. Now, 31A dealt with the conviction of a person who was an absconding. Now, that has been done away with. Section 31A has been deleted. Now, another section 31B has been added, and the purpose of that amendment is now the chairman NAB has been authorized to withdraw pending trials as well as the proceedings. And now you would understand what is the purpose of doing this. Purpose of doing this is undertaking these amendments and exercise, which I would say futile exercise, because these are on the face of it discriminatory, because they are taking away, violating a number of constitutional rights under the chapter of fundamental. Now, equality before law is one thing. Now, Article 13 is another section which says that yes, you cannot make a retrospective law, criminal law, but at the same time, you cannot undo a law under which certain convictions and proceedings are taken. So, the purpose of this new amendment is to give benefits to specific person. It is a person specific. I hope I have answered your question. In fact, if you look at the scheme, it has taken not only the teeth, but the whole body of the NAB law. I would not say that they have taken out the teeth of this law. Or investigation, now the threshold, I give you an example. Now the threshold has been increased a minimum amount to 500 million rupees. Now, in cases of banking and finance, the permission of state bank is necessary. It was already there, but it has been further strengthened. Now, the chairman NAB has the power to withdraw investigation and even proceedings pending before the trial court. So, in my overall reading of this law, if you juxtapose the original law and these two amendments which have taken place in less than 3 months, the purpose is so obvious that the existing government is trying to take benefit out of this legislative process to undo convictions and do away with the investigations which are undertaken. So in my view, it will only derail the process of accountability in this country. But if I would qualify this whole thing with my earlier statement. I am of the view that a consensus-oriented NAB law review is not necessary. Now, practically no opposition to this whole legislative process in the National Assembly. And in the Senate, now things have so much changed that no legislation can be stopped, or there is no proper debate going on before is undertaken before the law is passed. So my opinion is that the whole purpose of this amendment is to derail the process of accountability. You see, plea bargain is a universally accepted procedure, where in order to avoid the long and lengthy trials in such matters, and you have seen that despite the time limit given in the NAB law, no trial is concluded not only within the prescribed time, but it takes years. So I personally think that plea bargain is a very good step, provided it is done in a fair manner, because even plea bargain should not be used to enrich NAB or any institution. It should be a very open process. But now this very right has also been qualified, and with retrospective effect. Now, if somebody has entered plea bargain, now he has been given a right to dispute this plea bargain under certain grounds. On certain grounds, for example, he may come to the court and say that I entered into this plea bargain under coercion. There was a duress. I was put under pressure to enter into the plea bargain. And again, there is a method in madness. There must be a mischief behind this amendment, because no common man has ever come forward. I think even this process which has been amended, plea bargain in principle is a good thing. It saves states money on a long and lengthy trials. It saves courts time, but it should be done in a transparent manner and not to give benefit to any particular person. Well, you see, I am of the opinion that insofar as the political process is concerned, the best way is, and I always subscribe to the rule, that people are the greatest judges of their leaders. Provided the election process is free and fair, election commission is not disputed, its members their integrity is not questioned. But it seems to be that the purpose of this whole amending process of NAB is to bring back all those leaders who were forced to sit on the fence, which is a very positive thing. But at the same time, I must say that this process of accountability, whether it's NAB or FIA, should not be used to exclude other players in the political arena. So, insofar as the political leadership is concerned, whether people sitting overseas or in other countries, they should be allowed to come back and let the people judge about their leaders. There should be no political engineering. And if the purpose of these amendments is to allow a level playing field to hold free and fair elections in the country, it's a very good thing. But I hope That is the purpose, which seems to be on the face of it, the way amendments have been made, seems to be there is something behind this whole process. But my own opinion is that the political process should not be disturbed or interfered with the so-called accountability. And the slogan of accountability has miserably failed during the last week. It has been used as a witch hunt against the political opponents. That should not have any purpose. And more important thing is that our courts should rise to the occasion and allow themselves to oversee that every law and every process, every trial and every proceeding needs to take place in accordance with the guaranteed rights. Well, you see, I would have avoided commenting upon the petition which has been filed by Waqar Rana, questioning the vagaries of NAB law. I think it would be good thing that we see the judicial process fully examining the amendments which have been made in and they should examine. They have. I've generally seen the petition. I have not gone into its details, but I would rather reserve my comment because relief is not given on the bill. I am not of the opinion, and I don't think courts give relief. And this is an allegation against the judiciary that the relief is given based upon any particular person. Courts are independent; they follow the law and the constitution. And if any provision of this new NAB law is against the constitution, so courts will declare it ultra vires of the constitution. But whether it is Imran Khan or whether it's A or B or any political leader, if you recall in 2010 when this NRO was challenged before the Honorable Supreme Court, then who were the people who were behind that challenge before the Supreme Court? All these political leaders went to the court and the court threadbare discussed the provisions of NAB or this National Reconciliation Ordinance and struck it down, and that judgment still holds the field, and possibly that may have effect upon the present challenge to the amendments. So with this comment, I will not go into details because of the pending petition and Islamabad Act, because there is a petition pending